3 months after that interview, Sarah's attorney received a cease and desist letter from a law firm representing an unnamed party, threatening legal action if Sarah continued to make defamatory statements about individuals not party to the convicted matter. The letter cited the court sealing orders as evidence that Sarah's public statements violated the privacy rights of protected persons. Sarah stopped speaking publicly. Her attorney told a legal journal that they'd been legally silenced by the very system meant to protect victims. Ghislaine Maxwell was sentenced on June 28, 2022, to 20 years in federal prison. During the sentencing hearing, Judge Nathan allowed 7 victims to make impact statements. Their words were powerful. They described decades of trauma. They described childhoods stolen. They described the lifelong impact of what had been done to them. But none of them named anyone except Maxwell and Epstein, because to do so would violate the protective orders still in place. As of today, more than 2.5 years after Maxwell's conviction, the bulk of the documents in her case remain sealed. The flight logs that were entered into evidence are sealed. The financial records showing payments to and from various entities are sealed. The depositions of witnesses who weren't called to testify are sealed. The photographs and videos seized from Epstein's properties are sealed. And the Maxwell Protocol has been cited in 43 federal cases as of December 2024. It's been used to seal evidence in corruption trials, fraud cases, and even some violent crime prosecutions where the defendant has significant wealth or connections. Legal scholars have a term for this: tiered justice. The idea that the legal system operates differently depending on who you are and what you can afford. But the Maxwell Protocol represents something more specific. It's not just that wealthy defendants get better lawyers or lighter sentences. It's that the law itself has been restructured to create a protective barrier around certain networks of power. The case has spawned a quiet legal industry. There are now attorneys who specialize in high-sensitivity criminal defense, a practice area that didn't exist before 2020. They advise clients on how to structure their affairs so that if they ever prosecuted, the maximum amount of information can be sealed under privacy protections. They draft pre-litigation agreements with business partners and associates that include mutual non-disclosure provisions enforceable even in criminal proceedings. One of these attorneys, speaking on condition of anonymity to a legal trade publication in 2023, described it this way: Maxwell showed us that the law doesn't have to be about transparency if you know which rules to invoke. Privacy law, victim protection law, national security law, they all create legitimate reasons to seal information. String enough of them together and you can build a wall around an entire case. There's a story we tell ourselves about justice, that it's blind, that it treats everyone the same, that the truth eventually comes out. The Maxwell Protocol reveals that story for what it is: a comfort, a myth we maintain because the alternative is too disturbing. Because here's what the documents actually show: the law doesn't protect the weak from the powerful. The law protects information. And whoever controls that information controls the narrative, controls accountability, controls justice itself. Ghislaine Maxwell is in prison. That's true. But the network she helped build, the people she connected, the system she served, all of that remains largely invisible, protected by the very legal mechanisms that supposedly brought her to justice. And every time another case cites the Maxwell precedent, that protection gets stronger, more layered, more permanent. The question isn't whether justice was served in the Maxwell case. The question is, for whom? If you want to see more investigations into how power shapes the law, subscribe to this channel. None of these laws are unusual, but together, applied in this specific way, they created a legal black box. And here's why it matters. Within 6 months of Maxwell's conviction in December 2021, at least 3 other high-profile cases began citing the Maxwell Protocols in their own motions. A prominent financier in Connecticut, accused of securities fraud and money laundering, filed a motion to seal all discovery materials citing the Maxwell precedent. A real estate developer in Florida, facing RICO charges, requested anonymous witness protection using the exact language from the Maxwell trial orders. A former state senator in New Jersey, charged with corruption, cited the Privacy Protection Act in the exact configuration used in Maxwell's case to keep donor records sealed. The protocol was becoming precedent, but the real horror story isn't in the procedural motions. It's in what happened to one specific victim who tried to break through the seals. Her name, in court documents, is listed as Victim 5. We'll call her Sarah, though that's not her real name. Sarah was not one of the 4 who testified at trial. She was part of what prosecutors called the broader pattern evidence of Maxwell's alleged crimes that supported the charges but was uncentral to the indictment. Sarah's attorney, a victim's rights lawyer named Lisa Bloom, filed a motion in March 2021 requesting that Sarah be allowed to make a victim impact statement at sentencing, and that her full testimony be unsealed and made public. Sarah wanted her story told. She wanted the details of what happened to her and who was involved to be part of the public record. The motion was denied on April 2, 2021. Judge Nathan's reasoning was that Sarah's testimony contained identifying information about uncharged third parties whose privacy interests outweigh the public interest in disclosure. Sarah appealed to the Second Circuit Court of Appeals. On August 19, 2021, a three-judge panel upheld the denial. The opinion, written by Judge Rosemary Pooler, stated that the protection of uncharged individuals from public association with alleged criminal conduct serves a compelling governmental interest. Read that again. The court ruled that protecting the reputations of people who might be connected to child sex trafficking was more important than a victim's right to speak publicly about her own abuse. Sarah's attorney tried one more avenue. She filed a motion under the Freedom of Information Act requesting any FBI documents related to Sarah's case that might not be covered by the criminal court's sealing orders. The request was denied by the FBI in November 2021, citing ongoing investigative concerns. But here's the thing, Maxwell had already been convicted. The investigation was over. Sarah gave one interview to a small legal podcast in February 2022. She described being flown to Paris when she was 17. She described a party at an apartment she now knows was owned by a French businessman with ties to multiple governments. She described being photographed, being handed from one man to another, and being told that if she ever spoke about it, no one would believe her because of who these men were. She described Maxwell as the person who orchestrated all of it, the person who made the introductions, who assured her it was normal, who told her that this was how the world really worked, and she described the feeling years later of sitting in a lawyer's office and being told that even though her abuser had been convicted, even though the facts were proven, even though justice had theoretically been served, her story would remain sealed, the names would remain protected, the system would remain intact. Judge Allison Nathan approved the motion on July 9, 2020. The second red flag came in September. Maxwell's defense team, led by attorneys from the firm Cohen and Gresser, filed what is known as a Rule 16 motion, a standard request for discovery materials from the prosecution. But embedded in that motion was something extraordinary. They requested that all materials obtained from Jeffrey Epstein's estate be subject to an attorney's eyes-only designation. This meant that even Maxwell herself would be allowed to review certain evidence against her without her attorney present and without the ability to copy or photograph any of it. The prosecution didn't object. Judge Nathan approved it on September 17, 2020. Think about that for a moment. A defendant in a criminal trial, facing life in prison, couldn't fully review the evidence being used to convict her. The third red flag was the anonymous witness protection. By November 2020, prosecutors had identified 4 primary victims who would testify. Standard procedure in trafficking cases is to use pseudonyms in court documents, Jane Doe, minor victim 1, etc. But the Maxwell prosecution took it further. They requested and received approval to keep the witnesses' identities sealed not just in documents, but in the courtroom itself. During the trial, which began in November 2021, the witnesses testified behind screens. Their voices were not altered, but their faces were hidden from the gallery. Even family members of the defendant couldn't see who was accusing her. Federal Rule of Criminal Procedure 43 guarantees a defendant's right to be confronted by their accusers. But here's the twist. Maxwell could see them. The jury could see them, but the public could not. And critically, the press could not photograph them or identify them in coverage. The legal justification was trauma protection. The practical effect was information control. Now we need to understand how this was possible, because none of this happened in a vacuum. Every motion, every sealing order, every protective designation was approved by a federal judge following established law. But those laws were being applied in a combination and scope that created something new. Let's start with the Victim Rights Act. Passed in 2004, it grants crime victims the right to be reasonably protected from the accused. That's the law used to justify the courtroom screens and the sealed identities. Prior to the Maxwell case, it had been used primarily in gang violence cases and terrorism trials where witness intimidation was a documented threat. Then there's the Privacy Protection Act, which allows courts to seal materials that contain highly personal information about third parties not charged with a crime. That's the law used to keep the flight logs and financial records sealed. Finally, there's Brady v. Maryland, the Supreme Court precedent requiring prosecutors to share exculpatory evidence with the defense. But here's where it gets interesting. In the Maxwell case, the prosecution argued that because so much material was highly sensitive, they needed to control how it was shared. Even with the defense, they proposed the attorney's eyes-only protocol, which Judge Nathan approved. On July 2, 2020, FBI agents arrested Ghislaine Maxwell at a remote estate in New Hampshire. She was charged with 6 federal counts related to the sexual trafficking of minors, but within 72 hours of her arrest, something unprecedented happened in the American legal system. Her case was sealed under what legal observers began calling the Maxwell Protocol, a series of procedural maneuvers that would reshape how high-profile criminal cases involving the elite are prosecuted in the United States. What emerged wasn't just about one woman's crimes. It was a blueprint for how power protects itself through the law. The documents are public. The court filings are accessible. Yet somehow, the full scope of what happened between July 2020 and June 2022 remains obscured behind redactions, sealed motions, and procedural orders that legal scholars say have no precedent in modern American jurisprudence. This isn't conspiracy. This is court record. Today, we're walking through the specific legal mechanisms that were deployed in United States v. Ghislaine Maxwell, and examining how they've now been cited in at least 17 subsequent cases involving defendants with significant wealth or political connections. We're looking at how the law bent, and what it means for every case that comes after. Ghislaine Maxwell was born on December 25, 1961, in Maisons-Laffitte, France. She was the ninth child of Robert Maxwell, a British media proprietor who built an empire and died under mysterious circumstances in 1991. By all accounts, Ghislaine grew up in extraordinary privilege, educated at Oxford, fluent in multiple languages, connected to the highest echelons of British and American society. But here's what matters for our purposes. By the time she met Jeffrey Epstein in the early 1990s, she wasn't just wealthy, she was connected. Her father had cultivated relationships with intelligence agencies, political leaders, and financial institutions across 3 continents. When Robert Maxwell died, his body found floating near his yacht in the Atlantic. Those connections didn't disappear. They transferred. Jeffrey Epstein's network is well documented. We know about the private island. We know about the flight logs. We know about the financiers, the academics, the politicians. But what we're examining today isn't the crime itself. It's what happened when the law finally caught up with one of the key architects of that network. Because on August 10, 2019, when Jeffrey Epstein died in his cell at the Metropolitan Correctional Center in New York, the possibility of a public trial died with him. Every name in those flight logs, every detail of how this operation functioned for decades, it all died. Except for one person who knew everything, Ghislaine Maxwell. The arrest came nearly a year after Epstein's death. Prosecutors had clearly been building a case, but the delay itself raised questions. FBI documents later revealed that Maxwell had been under surveillance since at least November 2019. They knew where she was. They watched her purchase the New Hampshire property through a limited liability company called Granite Realty LLC in December 2019. They monitored her movements for 7 months. Why the wait? The first red flag appeared on July 6, 2020, 4 days after her arrest. The U.S. Attorney's Office for the Southern District of New York filed a motion to seal all pretrial discovery materials. This isn't unusual in cases involving minors. But the scope was different. The motion requested that all materials related to uncharged individuals be permanently sealed, even after trial. The reasoning cited was privacy concerns for victims and third parties. On its face, reasonable. But here's what that meant in practice. Any document that mentioned anyone other than Maxwell or her direct victims could be hidden from public view indefinitely. The names, the flight logs, the financial records showing who paid whom, all sealed.